So I'm going to turn it over. I'm going to ask Tom Devine to get us started. He usually starts off by talking about our federal whistleblowers. So Tom, over to you.
Thanks, Jackie. I'm going to start and talk about federal whistleblowers because that's my assignment this month. Really, my assignment is to discuss what's the health of the merit system, the rights of federal employees to blow the whistle, or simply have a civilized opportunity to perform their duties professionally. And I'm sorry to say that basically the merit system in the United States is on life support. There hasn't been any congressional oversight hearings on the Whistleblower Protection Act since 2017. At the Merit Systems Protection Board, which is the only due process forum available, the administrative law judges rule against whistleblowers 96 to 98% of the decisions on the merits, depending on the year. This isn't surprising because the pool of administrative law judges comes almost exclusively from former agency lawyers and judge advocate general lawyers who cut their teeth professionally and developed their whole careers fighting employee rights and defending agencies that were challenging employee rights. At the full Merit Systems Protection Board, we've been very disappointed that the new board members that our community fought to get confirmed have been given consistently hostile decisions which shrink the rights under the Whistleblower Protection Act. And what's very frustrating is it takes so long for people to lose. It's like water torture before your rights are rejected. I've got a client right now whose case has been pending for 19 years under the Whistleblower Protection Act. It's not that surprising that the track record is weak because unlike every other sector in the U.S. labor force, whistleblowers who work for the federal government don't have access to court and a jury trial to defend their rights. They're shunted off to these administrative law judges who are almost hopelessly biased to start with. All the corporate employees in the United States virtually have access to court and a jury trial. All the state and local workers have access to court and a jury trial, not the civil service employees. Civil service workers in the federal government can't defend themselves against retaliatory investigations until the other shoe drops and there's some action taken on, which means that you can have a witch hunt hanging over your head for 5 or 6 years and being an example to everybody else to remain silent. It means that the government can circumvent the entire Whistleblower Protection Act and make a criminal referral for prosecution based on the retaliatory investigation, and you have no rights at all. And what's particularly frustrating to me is that the Whistleblower Protection Act for federal workers only covers employment actions. It doesn't cover the full scope of harassment, such as harassment against your family or retaliatory litigation. Slap suits, I mean, as one of the folks here this morning, Debbie Shaw, can testify, can attest. Debbie won her retaliation case. Her whistleblowing forced the departure of an inspector general who was abusing power, but now she's facing a slap suit. Slap suit for being right, and it's hanging over her head. 2/3 of the nations globally, and almost all the whistleblower laws passed in the last decade in other countries, protect whistleblowers against retaliatory civil or criminal prosecutions, not the United States. Well, you know, you have to have a little bit of that with all the gloom and doom and everything. And so I'd like to share some news that's good news for our community. We have a new special counsel, Hampton Dellinger, and Mr. Dellinger is off to a very good start. He's scheduled quarterly stakeholder meetings, and these are the first stakeholder meetings we've had in almost a decade. And even then, it would be once or twice within 4 years. He's scheduling them 4 times a year to hear from the community. He also issued proposals a few weeks ago that are just serious nuts and bolts improvements in how your rights get implemented. For example, he has said that whenever the special counsel finds a substantial likelihood that a whistleblower is right, and orders an agency chief to investigate, that will be publicly posted. Up until now, you can get that significant confirmation, vindication from the special counsel, but it would be under the radar. Nobody would know about it. Now this will be public notice that an agency is put on the spot. And I hope that that will improve the quality of agency responses when they're not operating in secret. The second thing that he did in recent proposals is to enforce the law that's been the law since 1978, but ignored routinely, that agency chiefs have to sign the reports and vouch for the agency's response to whistleblowing investigation ordered by the special counsel. Up until now, they've had acting middle managers speaking for the agency. There was no indication that the agency leadership even knew about the issues raised by the whistleblower. Now they're going to have to take responsibility for how their institution responds. A third thing that's new is that when the special counsel does an investigation and finds a prohibited personnel practice report, they're going to post that publicly. Currently, they're just going to secret negotiations with the agency, and the agencies have really nothing to lose, and particularly in the short term, by defying the special counsel's recommendations. Now there'll be a public posting that an independent investigation has found illegal retaliation, and it puts the whistleblower on a much higher ground with a lot of wind at their back. And finally, the special counsel is committed to full disclosure on how they operate, which is a refreshing change. I've been bringing cases there for decades, and it's trying to represent clients before the Wizard of Oz. You never know what's going on behind the green door. Now they're coming out into the open. Folks, that's some encouraging news, and there's more encouraging things for us to accomplish if we work hard on it. For example, the Whistleblower Protection and Improvement Act was passed by the House of Representatives. It would close the loophole on retaliatory investigations. It would close the loophole on court access and jury trials. It would give people a realistic chance to get temporary relief so that the reprisals are frozen while they fight their cases. It would close the loopholes that have demoted climate change scientists at the National Ocean and Atmospheric Administration and public health scientists at the Public Health Service from being only covered by the military Whistleblower Protection Act. It would allow whistleblowers who win to get promotions that they could have received during the 5 to 10 or 15 years that they were fighting their case. It would allow them to get their attorney fees for winning at the administrative level. Right now, they can't get them, and this undercuts the quality of representation. There are good things that we can be doing, but perhaps the most significant thing I'm going to share this morning is the threat to not only whistleblowers, but the entire merit system. In October 2020, President Trump issued an executive order for something called Schedule F. Schedule F is an attempt to openly do what the Nixon administration tried to do in secret during the Watergate scandal with something called the Mallet Plan. It would replace the 3 million person federal civil service of nonpartisan professionals with a patronage labor force. It would cancel the merit system rights for the people who are in Title V position. And although it's advertised as just kind of a small group of people who are confidential policymakers, well, actually, fine print says that confidential policymakers who are not normally subject to change after an election, which means the competitive career civil service. And then there's the definition of what's a confidential policy job. Well, anyone who has discretion to enforce legal authority, anyone who works for someone or with someone who's GS 13 or higher, It would apply to all government lawyers and administrative law judges. If victims are hostile now, with the Merit Systems Protection Board, think when they're handpicked by a politician. And it would remove access to the Merit Systems Protection Board for all those who are covered by it. And they would go to the agencies where they work, which will be required to have programs to stop prohibited personnel practices. In other words, the same agencies that for 45 years have been the defendants in prohibited personnel practice cases would now be the judges and juries of their own alleged misconduct. So much for the merit system, so much for the Whistleblower Protection Act. This has been proposed to when President Trump implemented it. There wasn't time to actually implement the new executive order. The election was a few weeks away. President Biden canceled it and came out with a new regulation which will actually make it harder to do this again. But it's in Project 2025. If President Trump wins the next election, you can be sure that this is going to be on the front burner. It's one of those day one priorities, which is to replace the nonpartisan professional civil service system with a 3 million person spoils system labor force. We've got a lot of work ahead of us, folks.
Just pass. Yeah, why don't you guys, I think we're down to one microphone, but if you'll go ahead, Richard Condit, and then Cleveland from Mahari and Scala, who's also one of our sponsors, and you'll be enjoying lunch today thanks to them.
Well, hi everyone, nice to be here. Nice to see you all again. I see many familiar faces. I'm Richard Condit with the firm Mahari and Scala. My colleague and a partner in the whistleblower practice, Lawrence, is also here. And we're going to talk a little bit about whistleblower retaliation in the private sector and a little bit about the False Claims Act. Well, we have another panelist who's very esteemed in that area, so we'll give plenty of space for her. What I want to emphasize, which we try to do each year at this conference, is what folks in the private sector need to think about if they're contemplating whistleblowing. So if you're in the private sector, you may or may not be protected by a statute, either a state statute or a federal statute. A lot depends on the subject area or the industry that you work in and things like that. So what we often tell folks to do is it's really important for you to seek legal assistance right at the very beginning. If you're thinking about whistleblowing, if you've already blown the whistle, if you have experienced some type of retaliation, you think may be connected to whistleblowing, then you really do need to seek assistance from an attorney right in the early stages. And the reason I say that is because it's not simple. It's not like you feel like you've been wrong and there's going to be a remedy. That's not the way it works, unfortunately. The patchwork of laws that exist in the United States are just that, a patchwork, and you may fall in or outside of the patchwork. And so it's very, very important for you to understand what your rights are and whether you're protected or not as you move forward. What's also very important to know is what kind of information you can share if you're planning on blowing the whistle or have blown the whistle with respect to whatever wrongdoing you're observing in your company. So it is one thing to share information directly with the government if you're, say, making a disclosure to the Securities and Exchange Commission, to OSHA, or some other governmental agency. It's quite another thing if you take information from a company that you're working for and you share it with the media, or you share it with some other public source, or you post it online. That can get you into a lot of hot water and create potential liability for you. So it's very, very important that you understand what your rights are, and no matter how significant you think the wrong is, when you take information or utilize information from the company you're working for, you need to ensure that you use it in the right way, that you put it in the right hands, so that you are not subject to liability yourself for engaging in what is undoubtedly probably very valid. So we typically distribute to Jackie and the Whistleblowers America team here a slide presentation And I'm inviting Paul and Jackie to share that with everyone in the conference and to make it available more generally on their website. It gives you like all of the details of some of the things that I'm very generally touching base on with respect to different statutes, how many statutes there are, what kind of areas are covered, and things of that nature. So I invite you to look at that information, and I invite you to follow up with Cleveland or myself if you have questions, or if folks that you know have questions. We're more than happy to, and we often do almost on a daily basis, talk with whistleblowers who just have a question or just want to know, are they protected? Might they be protected? Some important issues. So we're happy to, freely give our time to help put people, in the right place and get them going in the right direction with their situation, whatever it may be. So to talk a little bit about private sector protections, just to give you a little bit more of an overview and a little bit of depth on it. There are probably, I think the Congressional Research Service has identified about 50 or so federal laws that have some type of whistleblower protection. And these range from everything from folks who are reporting, occupational safety concerns to folks who are reporting, financial frauds within companies. And again, if you look at our slide deck, we'll provide a lot of detailed information in that. But there are a few main ingredients that are common across all types of whistleblower laws for private sector. One is, first of all, are you protected? And so that's pretty much a function of the statute that you're working under, whether it's a state statute or a federal statute, or in some cases it can be a common law protection that you may have under a state common law. So that's the first issue you want to cover is, are you protected? If you are protected, the next question is, did you engage in some kind of protected activity? And that again is often a function of the subject area covered by the statute that you may fall under, or the other law that you may fall under. So, are you, if you're again using the OSHA example, if you've reported something about a workplace safety issue, is that something that is something that OSHA would cover or regulate? If so, then under the Occupational Safety and Health Act, you would likely be protected in some way. And then the question is, have you experienced what the law refers to as an adverse action? If you've been terminated, you certainly have experienced an adverse action if that termination is connected with your protected activity. But a lot of times people are in situations where they're not terminated. Perhaps they're demoted. Perhaps they don't get a bonus. Perhaps they're moved into a position where ultimately they're easily vulnerable to layoff or some other situation. These lesser types of actions by companies, short of termination, often need to be evaluated fairly carefully to determine if they're the type of action that might be covered under protection under any of the statutes. And then finally, did the person experience any kind of damage from the action that was taken? Of course, if you're terminated, then the damage is obvious. You lose your pay, you lose benefits, other things. If it's another lesser adverse action, then it may not be so obvious what the damages are. And most of these statutes do that are federal in nature do provide a scope of protections. A lot of them are focused on what's called making the person whole. So they may be back pay, compensatory damages, which can be anything from emotional suffering that you've experienced to the cost of moving or job searches or other things. And then many of them also provide for attorney's fees and costs, a fee shifting provision, which would require the company to pay your attorney's fees if you're successful. So that's the overview. What I'd like to do now, though, is turn it over to my colleague, Cleveland Lawrence, to talk a little bit about one of the reward programs that are in the federal sector, which is the False Claims Act, and to have him tell you a little bit about how that works and what people can expect if they're seeing a fraud situation involving government contracting and they want to contemplate whether or not that situation falls under the False Claims Act.
Yeah, I think one of the key distinctions about some of the outward facing whistleblowing that Richard was was more focused on. And the False Claims Act is that the False Claims Act retaliation provision allows for internal reporting efforts to stop fraud on the government to really be the thrust of protected activity. And filing a whistleblower complaint is not required. False Claims Act, and as background, the False Claims Act is federal and adopted now by about 30 states. A federal statute that allows whistleblowers, individuals, groups of individuals, corporations, etc., to file a lawsuit on behalf of a government agency that's been defrauded or attempts have been made to defraud that agency. And if that lawsuit is successful, it can return up to 3 times the government's actual damages as well as substantial civil penalties. And some of that money is used to pay a reward to the whistleblower who brought that lawsuit, anywhere generally between 15 and up to 30% of the government's recovery from the suit. So Congress sort of quickly realized that most of our whistleblowers under the False Claims Act are going to be insiders, employees. They extended those protections to contractors and agents to be more specific. But they included retaliation protections against whistleblowing or against discrimination. And so among those protections is any effort to stop a violation of the False Claims Act, to stop some attempt to cheat the government out of money. And that oftentimes involves internal reporting. And so lots of times people that we meet with will come to us with employment claims because they're being harassed and discriminated against. The litany of issues that Jackie has expertly taught us so much more about, mobbing, isolation, etc. They're experiencing those things on the job, up to and sometimes including being terminated. And it's because they are rocking the boat about some scheme that the company is involved in that involves ultimately False Claims Act violations. So a lot of our PTAN, our relators, our whistleblower False Claims Act clients come to us as employment clients, as retaliation cases, and sort of become expanded. They're not always whistleblowers who know that there's this amazing law that allows people to sue on the name of the United States of America and recover money, but to keep a percentage like it as their reward. They often come to us because they are experiencing severe issues on the job. I want to leave some meat on the bones for Ben and Regina, so I'll pass the microphone. But I do think that it's important to note that there are circumstances where even if you're blowing the whistle internally and you start to receive that pushback, the earlier the better to document and potentially consult with counsel about what your rights are based on what you're experiencing, the better.
Thanks, Stephen Richards. So I'm Gina Poserina. I'm from Philadelphia. I work with Kleinman and Associates, which is in Austin, Texas law firm, where we file cases all over the country. And I've been, not been, but I've known these guys for quite some time. Lee and Richard have talked about the variety of federal statutes, and certainly I represent clients under those acts, and most of my practice does fall under the False Claims Act, but there are also plenty of state statutes that can protect people in employment matters. But unfortunately, many of those state statutes are very restrictive. If you are lucky enough, like me, to practice in the state of New Jersey, we have something called a Conscientious Employee Protection Act that protects someone who blows the whistle on issues of public policy. And it's a statute with a lot of teeth. But there aren't a lot of state statutes that are that protective. I created a PowerPoint that I'm not going to go through, but certainly Paul and Jackie will have any materials available to you. But one of the things that I I did focus on in that is state statutes. And the majority of the state statutes are really tied to healthcare. Or to fraud that's specifically on state dollars. They aren't going to provide you as much protection or recovery as, say, an OSHA statute would, or a transportation statute would, or the False Claims Act statute would. But they will at least provide you with some protection. For instance, in Texas, Texas has a Texas Whistleblower Act that provides employment and protection to state employees who report illegal government activity or government agency action. And it also protects healthcare workers who report abuse. Pennsylvania has a law that protects state employees who report fraud, waste, and abuse. Unlike Texas, you have to be reporting something that the agency itself did that was improper, whereas Pennsylvania's act is specifically saying that you can report fraud, waste, and abuse on the Commonwealth of Pennsylvania. Some states also provide protections to persons who report violations of public policy. But what many of these statutes get back to, and Green, your example was a really good one. If you go to a lawyer, and I'm saying this just not necessarily to sell our services, but if you go to a traditional employment lawyer, most of them don't understand these statutes, these whistleblowing statutes. And so it becomes very important to find an attorney who does understand whistleblowing statutes, because many well-meaning employment attorneys have never heard of this one. And it's interesting because you would think that they're employment lawyers and that they understand all aspects of employment. But just like you were a pilot and you don't understand what lawyers do, it's the same type of a thing. And so it is important to find someone who really understands what it means to be a whistleblower lawyer. In addition, many states at this point, 29 states, including the District of Columbia, have False Claims Acts too, to report fraud and abuse related to the state funds. Curiously, Pennsylvania has its own whistleblower statute, but does not have a False Claims Act statute. Many other states are the same. But not all of those statutes protect whistleblowers aware of fraud on the state government. For instance, I think it's Michigan, it's only a Medicaid fraud statute. So if you're aware of Medicaid fraud, that's great, it will protect you. There's a really short statute of limitations, but it will not protect you if you're aware of other state funds being misappropriated. So again, it's all a matter of finding someone who can help you, but also being able to understand what laws can protect you. Unfortunately, we find, and I'm sure everybody would agree with this, we find many times that there's not a statute to protect whistleblowers. And that the best thing may be to do a traditional employment suit if that is appropriate. A couple of things that Richard and Cleve talked about that I want to kind of emphasize. And actually, I meant to start what I was saying with this. Arlene made the comment, I wrote this down, your life is not going to be over, it's just going to be different. And I think that's probably the best advice that any lawyer can give a whistleblowing client, because you may not ever get your job back. And you need to accept the fact that your life is going to be different. You need to have a positive attitude, which is a very nice thing for me to say, but an extremely hard thing to do. And you need to have, I always find my whistleblower clients who have the support of someone else in their family are the ones who end up the best. Because having some kind of, whether it's family or outside support, makes a huge difference in their ability to, as Darlene did, keep it all together. So very important, like, despite everything your daughter was going through. Richard talked a little bit about taking information from your employer. And there's something I want to caution people about, which is this. If you're working for a private employer and you're taking documents for purposes of showing that you've been a whistleblower, It's very important to understand that you really should only take documents specifically related to the issues of your whistleblowing. To take documents that you think might be helpful but really are not related can be extremely problematic. In addition, to take documents for purposes of a federal False Claims Act is usually a little bit easier because since those documents are going to be turned over to government investigators and federal authorities, there are protections for those documents. But under many other statutes, and especially state statutes, there are no protections. And many whistleblower employees are then countersued by their employer or former employer for taking those documents. So again, talking to an attorney from the beginning before you take anything becomes crucial, because when it gets time to settle the case, the employer will still be holding over your head, but you took documents. Technology is a wonderful thing, but I found out 10 years ago how well employers, especially big employers, can figure out what you've been doing with your computer and what you've been accessing. About 10 years ago, I represented a man who complained about talking to defense fraud by his employer, and he traveled for them. And they could see that on his laptop, when he was in hotel rooms, he was downloading movies, not porn, movies. And they said that he was using his laptop for inappropriate purposes. And that, I mean, it was a dumb claim against him, but they could also see every single document that he had downloaded. And I'm finding that more and more. They want a forensic picture of your laptop when you turn it back in. They can see when things are downloaded. I had a client about 3 or 4 years ago who downloaded everything that he had ever touched, which would be okay, except many of them were documents that he worked on with other employees. And it just got excessively ugly. So very important before you take anything that you have some legal advice about what you're taking and whether or not you should take it. There's always the people who take those documents and email it to their own personal email account, which is great, and that's a little bit more helpful. But again, through forensic imaging of computers, your former employer or your current employer can see everything that you take. Protected activity. Richard talked a little bit about protected activity, and depending upon what kind of statute you're looking at, protected activity can mean a variety of things. But one of the things I find most difficult, or perhaps most helpful, is that whistleblowers put something in writing. Carlene says her union told her not to put something in writing, and I'm sure they did. But one of the ways that you can protect yourself is to create some kind of, even if it's short, memo about what you've seen and what has concerned you. In the best of all worlds, throw in a law that it violates. Under the False Claims Act, if you can say this is fraud on the federal government in the memo, or I believe this is fraud on the federal government in the memo, then that protects your retaliation claim under the False Claims Act. But as to other statutes also, it's very helpful if you put more than one person on notice of the fact that you've had complaints, made the complaints, here are the people that you've made the complaints to. Now, I know saying that and actually doing it is an extremely hard thing, because it's hard enough to go and confront someone in person about this. It's even harder to go to that person's boss and put it in writing. And I would say 75% of my clients don't do that. It doesn't mean that you won't have a case and that your case won't be successful. It just shows that you put your employer on notice that these were your concerns that are not being taken seriously. Damages. The reality of our world representing employees who work for private employers is that if you don't have damages, it's going to be hard, or aren't able to sue under a statute where your attorney gets paid. The reality is it's going to be hard to find a lawyer to represent you. But, I've often told my clients, keep some kind of notes of what you've gone through. I don't need you to write 10 pages on your emotional distress, but certainly today at work, X, Y, and Z occurred. Those notes, if it goes into litigation, would likely have to be turned over to the other side, so you don't want to get overly personal with them. But you certainly want to be able to keep track of it, because I know as I age, I can't remember when it was that I did a certain thing or talked to a certain person. Now add the stress of what you're going through as a whistleblower, and you're really not going to remember. I always joke now that when I buy into appliance, I want to get a Sharpie and write the date on it so that I have even a clue when we got that dishwasher. So these issues of what occurs at work are certainly going to be more important to you than when you bought the dishwasher. But having some type of a notebook where you're able to keep track of that information can, even if it's just a little note, can trigger other memories for you that you could then talk to your attorney about. And the same thing for adverse actions, as far as keeping notes of not just the damages that you've suffered, but also the adverse actions that have happened to you, which can be as extreme as I know one whistleblower who was put in a room where they stored the toilet paper, and that's where he worked, they took away certain responsibilities from me. I'm no longer, even if it's something small, I'm no longer in charge of the party planning committee, which was one of my favorite activities. And the date that occurred. But all those types of things are extremely helpful to your attorney, no matter what statute you file under, to be able to create a case for you. So now I'm going to hand it.
Thank you, everyone. This has all been very insightful. I'm going to focus on a little bit different way of whistleblowing, which is the use of whistleblower reward programs. So these reward programs operate based on information rather than retaliation. So it's about the quality of the information that you're able to provide rather than the amount of retaliation that you suffer. So first, I'll go into the nuts and bolts of how these programs work. Then I'll talk about the effects of these programs and why they're so important. Then I'll give you some tips for how to be a whistleblower with these programs. So the four main programs are the SEC whistleblower program, the CFTC whistleblower program, IRS, and the AML program, which is run by FinCEN and the DOJ. So the SEC program, that's the largest. It's been around since 2012 with the Dodd-Frank Act. And last year they received 18,000 tips for of violations from whistleblowers. So what they protect is anything that is fraud on investors. So if there's a company that's publicly traded or privately traded, if the investors are defrauded, if the company is hiding information from investors, whistleblowers can report that information. That can be very significant. That ranges for anything from a culture of retaliation, so therefore they're not able to retain proper talent, and that will affect the share price, and therefore it's fraud on the investors. Two, they're cooking the books, and it's a Ponzi scheme. All of that goes under the SEC whistleblower program. It's one of those things where anything can kind of fit in that box of you're defrauding investors, so it's very broad. And it's incredibly effective. Last year, I think 90% or so of SEC claims were brought from whistleblower tips. This has been shown to be effective. The CFTC whistleblower program protects commodities markets. So if there's commodities such as oil, coal, gold, anything like that, if you're defrauding the market in that way, you can bring it to the CFTC whistleblower program. IRS program, taxes. If you know that a company is not paying their taxes correctly, if you know that a person is not paying their taxes correctly, you can bring it to the IRS whistleblower program. They love everything. If your ex-husband is not paying his taxes and now you want to report him, they'll do it. It's surprisingly common. They also do money laundering under Title 18. So if there's money laundering going on, a specific instance of money laundering, IRS has jurisdiction over that as well. Now the AML whistleblower program, What they do is they look at money laundering as well, but they do it from the systems that a bank or financial institution has under the Bank Secrecy Act. So if you're a bank and you aren't properly IDing customers, you're not doing your KYC, know your customer, you don't know who's putting money in and taking money out, that is an AML violation under this program. Also, they have jurisdiction over sanctions. Money is going to Iran or other individuals who have sanctions against them. What we've seen a lot is oligarchs, Russian oligarchs moving money. And if you have information on that, that is a sanctions violation, and it's also an AML violation. This program, it was improved in the end of 2022 to be effective. That brand new program is with FinCEN and the DOJ, and they have been incredibly effective so far. We've had great things. The regulations should be coming out. Well, they're supposed to come out this past summer. They have not yet, but they're working on it. So how this works is you submit what's called a TCR, or in the IRS's instance, it's called 211. You submit this with your information, the information that you have on these violations, and then you'll be working with the government attorneys, government investigators, to investigate this fraud. They will do the backbone. They do most of the work on the investigation, and you provide information as a witness. So what we do, we're your attorneys. We help you present your information the best light possible, and we protect you as a witness. Now, when you're submitting this, you have the right to be confidential. That is a game changer in whistleblowing. The company does not need to know that you are a whistleblower. For the SEC and CFTC and AML programs, you can also be anonymous, meaning the government that you're providing information to doesn't know who you are. You can write anonymous when submitting your information. For that, you do need a lawyer. You need to have a lawyer in order to be anonymous. Even without a lawyer, you are still confidential. They will not tell the company who you are. It prevents retaliation in the first place. So we all heard from Kathleen about how the tactics that companies use when they know that someone is reporting information, they will do everything in their power to discredit them. She can't be reporting safety violations because she's bipolar. They will find anything that they can to come against you with. If they don't know who you are, they can't do that. It puts them on the defensive. It means that they actually have to respond to these allegations of crime and fraud that they are perpetrating, rather than trying to lash out against the person coming against them, rather than lashing out against the whistleblower. Now, of course, protections are still important because no confidentiality is 100%. They have full knowledge of who has access to such information. So it is difficult. These programs will do things such as they'll issue subpoenas based on your information to get the information a separate way to try to block your identity further. They're done very good at this. They are very professional. They're very effective. So let's go into and then at the end, when a sanction is collected, these sanctions can be incredibly significant, up to billions of dollars if you're blowing the whistle on a significant enough of a fraud scheme. The whistleblower is then entitled to a percentage of that award. You're rewarding whistleblowers for providing good information and preventing corruption and stopping corruption. It aligns the interests of the whistleblowers and the government. Aligning those interests are important. You want to be rewarded for preventing crime. Every whistleblower I've ever talked to, their goal is to prevent the corruption that they've seen, to stop the fraud that they've seen. They want to do the right thing, and they want someone whose interests align with theirs. So let's go to the effect of this. One of it is the companies, they're scared of this because they know that they don't have a monopoly on you blowing the whistle. You don't have to go internal. You can still, but they know that if they don't deal effectively with your complaint, you can go outside and bring a government investigation on it, which is going to be a lot more of a headache for them than you going through their compliance program. Second off, a study from all of the retaliation, or not all, a study of retaliation claims from 2010 to 2018 found that 91% of retaliation claims were from internal whistleblowers, were brought by internal whistleblowers. 5% were from those who went externally to the government or another organization, and 4% did both. So you are significantly more likely to be retaliated against if you go internal than external because of these factors. Also, if you go to the government, you get significantly more retaliation protections under the Dodd-Frank Act, Sarbanes-Oxley Act. This is a sad reality based on the digital realty ruling in 2018. Another, the most exciting effect of this is that it changes the calculus of white-collar crime. So economists have long known that crime is a rational economic activity. If the benefits outweigh the risk of detection and the risk of punishment, crime will be committed. This is especially true in white-collar crime, where you don't see the victims. If you're perpetrating fraud on behalf of a company, you don't see the victims. You don't see the clients and the customers who are defrauded. You don't see the employees whose livelihoods you're putting at risk. It's small. It's little by little. And the rewards are pretty great. You get a ton of money through fraud. So one of the issues is detection of these crimes is incredibly difficult. Finding it through normal means of police work or law enforcement is incredibly difficult. Whistleblowers change this. Whistleblowers increase detection exponentially. As I said, something like 90% of SEC claims, SEC enforcements come from whistleblowers. So you're increasing detection that reduces crime. Now, what whistleblower reward programs do is change the entire equation, turn it on its head. Let's make whistleblowing a rational economic activity. Instead of making whistleblowing something done by those rare few heroes, let's make it rational. Let's increase the benefits of blowing the whistle and decrease the risk. This increases detection even more and makes criminals scared to perpetrate white-collar crime and commit corruption. This is the effect that these programs, when well administered, can have. So what makes an effective program? One, mandatory awards. Whistleblowers have enough risk in their whistleblowing without the idea that, oh, maybe my award will be discarded because someone in the government says I don't deserve it. At the end of the process, at the end of the whistle. Two, it needs to be anonymous and confidential. Whistleblowers need to be able to have that sense that they won't be retaliated against based on their whistleblowing. They need to be able to do it. They need to not have the company be able to retaliate against them. And where that exists is here in the US. We are at the forefront of these types of laws. But these are not just for in America. These laws have international reach. So it's not just the FCPA, which is included under the SEC whistleblower program. The FCPA is a Foreign Corrupt Practices Act. It's if a US company is bribing foreign officials. It's not just for that. Also, US companies or companies that have investors in the US, which includes cryptocurrency. If you have cryptocurrency investors in a cryptocurrency exchange, that provides US jurisdiction. If these companies are committing these violations anywhere in the world, as long as there's connection to the US has jurisdiction. Some of the best cases that I've worked on are from international clients in China, in India, in Africa, all over the world. These laws can work. They can utilize US laws without any issues, without any restrictions. All right. let's go to tips. So if you are looking to utilize these laws, what are some tips that you can do? As you said, downloading documents is incredibly difficult. So first off, remember, if you download documents, assume that the company will know who has downloaded everything and they can track everything. Anonymity is important for this because they won't know to look for you. They won't know to look at your computer, which helps, but it's not foolproof, of course. So one thing I've encouraged whistleblowers to do when they come to us is use your phone to take a picture of your screen. It's one of those things, if you're not downloading it, you're just looking at it and you're taking a picture with your phone screen, personal phone, not your work phone. Use personal devices. Don't use your work devices. They know who you email. Another thing is NDAs. So one of the barriers to going to the government or blowing the whistle to anyone is, do you have a contract telling you you cannot disclose any of this information? Now, a lot of the time, these are effective and they are allowed, but you cannot, an NDA or any confidentiality agreement cannot prevent you from providing your information to the government. The SEC has a rule, Rule 21F17A, which allows you to bring your information, despite any confidentiality agreement you have signed, to the SEC with violations of SEC regulations. These are not just, it doesn't just make this contract moot, it also it is a violation for them to have this contract, not just to enforce the contract, to have this contract. So if your employment agreements, your severance agreements include that, that's a violation. And the SEC has been enforcing that aggressively, especially in the past year. It's been very exciting. They've been enforcing that this past year with violations up to $10 million, $18 million against JP. And now the CFTC has enforced their rule, which is 165.19B. They've been enforcing theirs as well against traffickers. So that might signal a new start of enforcement of that. Now, if you go to the news media, this rule doesn't apply. What else do we have? I think that's all for my tips right now.
7 minutes.
Brian is here with us.
Yes.
Which is pretty amazing.
Hey, good morning, everyone.
Thank you. Yes.
Hope everybody's having a good day. Is it working on your end?
Yes.
We're good.
We're good. We hear you.
Cool.
Thank you for being here.
So I want to thank Jackie and her organization for inviting me to speak today to you guys. Put together, well, first off, I'm a Charleston, South Carolina-based attorney with an emphasis in whistleblower work as part of my practice. Myself and another lawyer, Rob Turkowitz, who's has a separate firm, but he also co-counsels with me on a bunch of cases together over the years. And we actually have been representing multiple Boeing whistleblowers from the 787 plant that was moved to Charleston back in 2010 timeframe. We've been actually at it with Boeing for about 12 years now, if you can believe that. We had 3 initial whistleblowers that came to us back in the 2012 time period out of the 787 plant. They were complaining about quality and safety issues. This has been quite a year. This past year, actually, with all of the dramatic events that have occurred in the aviation world and with my clients in particular. We represent over a dozen Boeing and Spirit Aero Systems whistleblowers presently. We had more, but we lost 2 of them in this year alone. One of whom was John Barnett. This is kind of difficult still for me to talk about, even. It's kind of a traumatic event, as the lawyer too. John was not only a client, he became a friend. We had been representing him since 2017 when he filed his Air 21 retaliation case against Boeing when he was working here in Charleston. He'd been at Boeing 32 years. He was transferred to help set up the quality department at the 787 plant in around 2010, 2011 time period. So, John loved the company, but he started raising very serious quality and safety issues internally to the FAA, and all he got was constant retaliation. And ultimately, his doctor told him if he didn't leave the job, he was going to have a heart attack. So we had alleged he was constructively discharged. We filed an Air 21 complaint with the Department of Labor. As you all may know, the Air 21 is the sole remedy for an aviation whistleblower. There's been numerous federal cases here in South Carolina where individuals have filed for retaliation. All have been dismissed with the court saying that Air 21 is their sole remedy. And there's some serious issues with Air 21, as Tom knows as well. I've talked about this along with Rob. There's only a 90-day statute of limitations. Nobody in the aviation world even knows about this statute. The companies don't educate their employees. They don't educate, their legal department or their human resources department or the workers on the floor. They don't even post signs in the plants that Air 21 exists. They would rather the employees not know that they have rights and what these rights are, which is unfortunate. Another issue with Air 21 is that you have to file a complaint administratively through the Department of Labor. OSHA investigates. They have no subpoena power. It's like a one-sided investigation. Of course, Boeing says, hey, we don't retaliate. We did nothing wrong. And it took 4 years in that case for OSHA to render an opinion that they did not find that John had been retaliated against. So your next step is you have to appeal that to the administrative law court, which is what we filed in 2021. And then you get a complaint, you get a judge, and then you can get into discovery. So for 3 years, we've been in the active litigation stage. We survived a partial motion to dismiss that we had alleged there was a hostile work environment at Boeing, and the judge ruled in our favor and found that there were sufficient facts that there was a hostile work environment there. Boeing continued its retaliation against John even during the litigation, we believe. They filed a counterclaim against him for millions of dollars of damages for allegedly breaching a non-disclosure he signed back in the 1990s. So in essence, they were trying to, put pressure on him, even in the litigation. We were successful in getting that kicked out on a summary judgment motion. He engaged in protected conduct, and he was trying to raise these issues of quality and safety that he was finding. So I'll give you an example of a couple. He found with the oxygen mask that deploy, there's a squid, which is like a firing pin that will allow the oxygen to operate. And during an investigation, he was finding that 25% of these were failing, that the oxygen was not deploying. And that's a serious issue if you're up 30, 40,000 feet in the air. You have decompression at that. You're going to have, within seconds, the science says that you'd have maybe 10 seconds and then 25% of the people will be dead. That's serious. And he raised that internally. He raised it to the FAA. Another issue was when they put the floor decking in on the they use these titanium screws called E-nuts. And when they are torqued into place, there's thousands of them per plane. There are shards of titanium that were falling onto everything underneath. And guess what's underneath? The flight control wires. So the last thing you would want is sharp, small slivers and thousands of these per plane now, falling into, either the wiring harness. So over time, that can cause the wires to short out, which could bring a plane down. Or it could fall into an electronic bay, which they have down there, and short out things that you would not want shorting out on a plane. So, John was also complaining about lost and non-conforming parts. So when the part is damaged or is comes in and it's not conforming, they have to cage it off in an area. And he found that all these people on the plant floor, managers, had keys and were coming in and just walking out with parts and falsifying documents and all this. I mean, it was a total disaster. And it seemed that the management was pushing everybody, just get the plane out the door at all costs. And that doesn't benefit any of us in the room. I mean, we all fly. And you're not building a table, you're building an airplane that carries hundreds of people's lives. So you want to make sure that you put out a safe and quality product. John was raising these issues before the MAX crashes. And as John said, this wasn't a 787 program issue. It was a Boeing issue, this mentality. Then 2 planes go down during the time that John had filed his Air 21 complaint. And in 2017, he had also been diagnosed with PTSD from his exposure to a hostile work environment. He was having anxiety attacks about planes crashing and people dying, and knowing that he was involved in building aircraft. He would wake up with nightmares for years on end. He would tell us about the visions of people crashing and dying. And Boeing doesn't make it easy. We've been through 3 international law firms, the defense counsel, during his Air 21 case since 2017. It's still pending, this case. His family, since he passed, it's been substituted, and we have a trial date in February of next year. Imagine that's a 7-year, 8-year process to get to a trial. So we were in the deposition phase back in March, and Boeing took his deposition on that Thursday. It lasted about 10 hours by the time it was all said and done. And then I questioned him on that Friday to get into evidence, certain things we needed to get into evidence. And, I could tell he was tired. And, as I said, John had become a friend. I just wish now, looking back, he would have said something to me that Friday. We didn't get finished. And, there was some argument with Boeing's counsel about postponing it and coming back at a later date. And they said, well, no, we're not agreeing to that. They don't agree to anything. They make it as difficult as possible on everybody. So we ultimately agreed to come back Saturday. And that Saturday, I remember it was raining very, very hard here in Charleston. And Rob was calling me that morning because the streets downtown Charleston flood when it rains like that. And we were talking about we're going to be a bit late. And he was saying, have you heard from John? I said, no. He said, well, I keep calling and it goes to voicemail. And I said, well, that's weird. Let me try to call. And same thing. So I said, why don't you call the hotel and have them, check his rooms? And so they did that. And then during the course of this, they saw his stuff in the room, but he wasn't around. We told him what kind of truck he drove. They went out and checked the truck, called us back and said that they couldn't tell us what was going on, but they had a situation there. And we're like, is he okay? Is he okay? Just tell us, is he alive? Did he have a heart attack, a panic attack? I'm thinking he had a panic attack. He's going into the 3rd day of deposition. And they said an officer would have to call us. So I knew at that point that that's not good. And the officer called Rob actually and started kind of interrogating him, like, who are you? Why have you been calling? We're trying to explain to her that we're his attorneys. He's been here for his deposition. And she wouldn't tell us what would happen. And we said, well, we were going to come down to the hotel where he was staying at. And she said, no, don't do that. I'll just talk to you around 4 o'clock after I get off the shift and let you know what happened. We're like, no. So we drove down to the hotel. And I remember seeing the police cars blocked off near his truck, and you could see medical personnel over there. And we went inside and talked to the manager, and she just said, I'm sorry for your loss. So, that was I've never had a client pass away on me. So that was quite a, shocking moment, and allegedly he had shot himself in the head in his truck, and he left we come to learn a suicide note that makes it really clear that what was in his mind was Boeing. The note is out in the public. Some of you all may have seen it, but that was just a shocking event. And John had been out in the media just trying to get the word out in the interest of public safety about the issues he had seen. And that evening, I was still in shock. And I thought, something's not right here. So I contacted the BBC CEO, who was a reporter I know there that had worked with John, that I trusted and liked. I told him allegedly they found him in his truck allegedly from a gunshot wound to the head. And he broke that story that Monday. And then I've never in my life had so much media and just random people calling, texting, and emailing me. It was hundreds and hundreds, and it was constant. And it was, I'm not a 1,000-person law firm. I have a small practice, and I'm still in shock from what has happened. But I thought the media needed to know because it was such an unusual situation, I'll say. And he didn't show any signs to us that he was suicidal or anything. He didn't talk to us about it, but he did have PTSD. And that can be a difficult thing for people, and there's a higher suicide rate amongst people with PTSD. And that is from what I've come to learn in working with Jackie as well on certain issues, is that that there are true mental health problems with whistleblowers, and they need to have support and counseling through the process to help them stay strong and continue the fight. So, during the course of this, there was a media firestorm about everything. And then I was in Europe at a international legal conference, and I started getting text messages from one of my clients, Josh, who was in Wichita, Kansas, that worked at Spirit Aero Systems. Spirit is contracted to Boeing that manufactures the 737 MAX fuselage of the plane. So they put the fuselage together and then ship it to Boeing in Washington and Renton to put everything in it and finish the plane. So I started getting text messages from Josh's dad. And Josh, by the way, was a 45-year-old healthy individual. He had blown the whistle as a quality auditor on serious quality issues he was seeing at Spirit, one of which the main one was misdrilled and mislined holes on the aft pressure bulkhead, which he documented almost a year before Spirit even acknowledged that was an issue. We believe they may have even concealed that from Boeing. And they ended up terminating Josh back the year before. But as I was saying, I started getting text messages from his stepdad in Europe, and he said, Josh has been airlifted from a Wichita hospital to Oklahoma City hospital. I'm like, what is going on? And he said he has multiple issues. He has influenza, he's got pneumonia, he's got MRSA, he's got staph infection, he's got sepsis, his hands and feet are turning black. And I'm like, what's going on? And he said, this just hit. Like he went into the hospital on Sunday. He complained he was sick on Saturday, just not feeling well. He went to an urgent care. He did not even have a fever on that Saturday. He gets admitted on that Sunday, and he's already in septic shock on that Sunday when he's admitted. I mean, it's really like, what is happening? And then I'm communicating with him while I'm over there. And ultimately, Josh passes away. He was on life support. Let me back up. They put him on life support immediately when he got into the hospital. I mean, he passes away within a couple of weeks. So now I've lost 2 whistleblowers against these 2 massive aviation companies, 2 of the biggest and strongest companies in the world. So you can imagine conspiracy theories swirled after that, saying that the companies have been taken out. It was just another traumatic event. So, my concern at that time was that this was going to hinder other people from speaking up. Because now they're saying that 2 aviation whistleblowers are dead within 2 months. But on a positive note out of this, we started hearing from dozens and dozens of Boeing and Spirit employees with issues of quality and safety, and that their real concerns were that they wanted the companies to succeed and to protect the public safety, the flying public. I'll tell you one other story. So around last summer, I was contacted by an employee at the Renton, Washington factory named Sam Mohawk. His name's now become public due to Senator Blumenthal releasing his Air 21 complaint that we filed on his behalf here recently. It was released during the Senate as a subcommittee on investigations that are investigating Boeing's safety culture. And many of our whistleblowers have brought information to them, including John Barnett and Sam Mohawk. And Sam works in MRSA, which is the non-conforming area that John happened to work in as part of his time, where John had complained about lost non-conforming parts. And Sam starts telling me that they're pressuring them to delete non-conformance records, which is the record that goes with each non-conforming part. I mean, and he's complaining of hundreds, if not thousands, of just missing non-conforming parts. So how would you lose parts like that? I mean, what is it? The employees carrying out big, huge parts of an airplane, taking them home, putting them in their backyard? No, I mean, the only logical reference you could infer would be that they're getting used on planes, which is a serious issue. I mean, we're talking, there's a federal statute, 18 U.S.C. 38, that makes it a felony with up to 15-year imprisonment per part if you fail to document it. It's also a $500,000 penalty per part. I mean, that's pretty serious. Somebody could go to jail for 15 years if they conceal a part on an aircraft. And we're talking hundreds, if not thousands of parts here. And Sam filed, Boeing, as part of their deferred prosecution agreement, had to strengthen their safety culture. So they created this thing called Speak Up, internal program. So Sam filed in October a Speak Up about all this. Not only that, I mean, he had other issues like they were storing parts outside, which is illegal under federal law. And then they were moving them when the FAA were coming in to do an inspection, which is not proper. And so he files a speak up. It goes on for months and months and months and months and months. And then what do they do with the speak up? So you would think they would have an independent, like, speak up division, like their ethics division. Now it goes to this one guy. He looks at it and turns it back and gives it to the managers that he's complaining about, his management that was making him, or trying to order folks to do this, to investigate themselves, which is totally illogical. And we all know that wouldn't work. So what did they do? They start retaliating against him. And so he received a corrective action. And then ultimately due to that, we filed the Air 21 complaint, which is still pending. Another one of our whistleblowers at Spirit, Santiago Paredes, knew Josh, or worked with Josh and followed it. Except Santiago worked at the end of the line, they call it, where the last inspection point is. And he was being pressured by senior management to document defects in an illegal manner. So instead of what they were wanting everybody to do, instead of documenting each defect, was to make a quadrant. And then ever how many defects were in there would be one. So it would skew the metrics, making it look like there were fewer defects. He refused to do this. So what do? They isolate, move him and take him out of quality and isolate him way in the back. So he filed an ethics complaint and then he wrote an email to the CEO. His ethics complaint was ultimately substantiated that he had been retaliated against, and he ended up leaving the company voluntarily. He just was tired of it. And we've heard from so many people at these companies that just voluntarily left because they didn't want to be a part of what was being produced. Boeing has totally lost their way, as I think everyone sees now. I mean, they got astronauts stuck on the international space. They have to get a competitor now to go get them. I mean, and that's all due to quality issues. They went $2 billion over budget at NASA on that thing, and it still didn't break. They had airplane doors blowing out in January this year. They could have killed a bunch of people. I mean, they need to get refocused on quality and safety. I mean, they've said that over the years that our main priority, our top priority is quality and safety. They say that to investors, they say that to the public. Well, obviously that's not true. And the FCC has actually opened a probe into both Boeing and Spirit related to their safety and quality statements. So we're hoping that the FCC takes action as well as a deterrent to these companies and slaps them with a really huge fine to deter the conduct, because these companies don't understand. The bottom line, if you hit on there, that's where it'll make them change their ways. So if people were to go to essentially to jail, I mean, if you got managers that are not terminated or not disciplined and they're pushing people to commit felonies, those people need to either get terminated or prosecuted, in my opinion. And if that happens, then people will really see this kind of conduct is not tolerated. And I could actually go to jail for it. That's a deterrent. And that's what these companies need, is deterrence. So, hopefully, with the Senate investigations and the DOJ investigations and the SEC investigations and our continuing folks speaking up and bringing information to the government will help Boeing change its way and get back on track, which it needs to do. It has to succeed. This company cannot fail. It has too much interest on the whole world economy and our defense side. So it has to succeed. And that's what we hope to see. I mean, so much has happened this year. I could talk for hours about this. But I think that's just kind of an overview. I had a PowerPoint. But I just spoke from the heart on this one, so,
Yes, you did. Thank you, Brian.
You're welcome.
I know it's been a lot and that you and Rob have been through a lot. So I really appreciate you sharing that and for really hitting home the points that that there's so much of what whistleblowers go through and apparently what their attorneys can go through as well. And when you build these relationships, you work on these cases for years and years and years with your clients, you really get to know them and their families. And it becomes personal as well, sometimes for the attorneys who work with us. So maybe we need more mental health for attorneys who are working with whistleblowers because this trauma just spills over. We've talked about the secondary trauma with families, but I think it's an even bigger community. I wanted to give people a chance. If anybody has a question and want to raise their hands, I'll bring you the microphone. And then I'm going to introduce the lady in the back who joined us from the Legion, Ms. Nelson, and let her welcome you here for a few minutes. But I don't want to skip questions. I know you guys want to talk about, okay.
This question is for Benjamin.
Yes.
In the complaint FCC. And nothing has changed at Delta. And they are advertising safety as our top priority. So could I write a FCC claim that they are fraudulently telling their shareholders this and then give them all the details where safety is not their top priority?
That I can't give you advice on whether to file or not, obviously, but here.
Don't advise if I should or not, just could I? Not should.
Absolutely, yes. So it is definitely legally possible for you to file a claim with the SEC based upon safety violations at there. Absolutely. Yeah, that's one thing is that is something that can hurt their bottom line. Going to the FCC and having them bring a massive case for all of these issues, that is something that will hurt the bottom line and make them change their tactics.
That. So one of the things I meant to say earlier, and if you are considering filing a lawsuit or know people who are in the process of being retaliated in my PowerPoint, I laid out what you need to do to prove a False Claims Act retaliation claim. And the False Claims Act has specific steps of what you need to do to prove a whistleblower retaliation claim, but the guidelines that they have are good for anybody under any statute. But you know, Colleen talked about all the efforts that she's taking since her lawsuit resolved to try and bring about change. And one of the hardest things for whistleblowers after the whole process is over is not just decompressing from all of it, but also realizing that for many corporations, this is just about the money. They want to pay you, they want to settle your lawsuit, and likely they do not want to make the changes that you're asking to have made. One of the beauties of things like the SEC whistleblower program, especially if your employer is a publicly traded company, is that the SEC will force them to make those changes. So, if you are physically and mentally able after your lawsuit is over to get with like-minded folks to try and cause a change in your industry, go for it. I think it's a wonderful, wonderful thing, because we all know these industries need tremendous amounts of change, but it becomes your life work. The SEC program, the AML program, all the programs that Ben talked about are programs that will force the companies to change.
I just have, as been mentioned, the SEC gets tens of thousands of tips every year. I think the question in this kind of context would be, the same as like a false advertising kind of question. Is that kind of statement what advertisers call puffery? It's our top priority, and we can show, well, you have a priority list and it's not number one, or is it just sort of fluff? I think a stronger case and a case that the commission would be more likely to stand out is if there is some safety violation that's reportable, that has to be disclosed to a government regulator, and it's not being disclosed, and they're making some statement in their financials that they're in compliance with all applicable regulations, and you know that they're not, because they're not disclosing this massive regulatory violation. I think that would be, a more tangible lie that would have an effect potentially on the market and investors, versus something that's a little more squishy. I will add also, there are a few other agency whistleblower programs, each of which has its own quirks and problems. The Department of Transportation operates a program that's all about auto safety and allows employees and contractors within that industry to build a whistle to the department. And it's the Department of Justice also operates a couple of whistleblower programs. One through a weird set of civil laws that apply to criminal violations called FIREA in the financial world, that allows whistleblowers to alert the Department of Justice to its ability to file FIREA lawsuits against financial, or sometimes on behalf of financial institutions, and the whistleblowers can be rewarded for those cases, and sometimes even be authorized to take over those cases. And the Department of Justice recently launched its own sort of whistleblower program in the corporate financial world, looking for criminal violations that can result in forfeitures, and under that program they have some authority to issue rewards to those people as well. So this concept is starting to catch on more and more, particularly in the cryptocurrency space, where a lot of agencies feel that their reach and touch, that sphere, the SEC and CFTC are constantly battling about who has jurisdiction over trading cryptocurrency. Defense and AML program obviously is looking at those transactions for money laundering concerns. The IRS has some interest in tax evasion, crypto, DOJ and lending programs. So I foresee these agency programs being, sort of the next wave of whistleblowing, and people questions like those are going to be found to be like,
Is perjury criminal?
I have a perspective that's consistent, but a little bit different angle on your question, Charlene. I'd recommend the False Claims Act as opposed to the rewards program. If your goal is to seek corrective action as opposed to compensation. Under the rewards programs, you just give the evidence to the government and hope that they do the right thing with it. And as pointed out, a lot of times they do. They require corrective action, not just a fine. Under the False Claims Act, though, you have a right to fight for corrective action that will make a difference. You're a party to the challenge of fraud. The Justice Department can take over its lead in the case, but you still are, even then, you're an intervener. You're enfranchised in the lawsuit. And then when it comes time to resolve the lawsuit, you can object to any settlement that doesn't include corrective action. And I'll give you an example of that with one of our clients who chose to go to the False Claims Act. He was blowing the whistle on fraud and calibration testing devices. Everything in the world has to be calibrated properly to meet its specifications, including airplane parts and the angles of wings and everything else, down to medical implants, from the largest to the smallest. If we don't have accurate data that those products met their specifications, there could be tragedies. So you have to have testing machines to make sure that the calibration is done accurately. One company was putting out a new testing machine that was much cheaper than everything else in the market and had more bells and whistles and doodads and gizmos on it. and it was taking over the market, being used by everyone. The whistleblower found out that whistleblower who is responsible for servicing these machines found out they couldn't be serviced because they were getting arbitrary data. They were a complete fraud on the consumers. Without a false claims act suit, because the government was the customer for a lot of the fraudulent products. And the government wanted to just settle it for money. He said, I'll go to court, I'll challenge this settlement unless there's a recall and all these phony testing machines are removed from the market and the division that was responsible for producing them is shut down. And the government didn't like it, but they had to blink because the whistleblower stood his ground. And so I kind of prefer the False Claims Act as a better vehicle to making these deadlines.
And I thought I heard you ask a question about perjury or lying, and I think we all have dealt with when the government lies, is it a crime? Anybody?
If we lie to the government, it's a felony. If they lie to us, it's politics as usual. I wanted to do a supplement to Gina's excellent presentation, in particular about avoiding liability for stealing documents. This is a major, major step. When I go to continuing legal education programs, the corporate lawyers are teaching everybody, go after the whistleblowers for stealing company property. That's a crime. You don't fight an alleged crime by committing a crime. And one way which I very much agree with is using your private phone to take a picture of the documents. Another way that's also a way to avoid detection is by, in the course of routine business, making a copy of the documents. When you've got a good business justification to do so, because these corporations have red teams that trace every transaction back to the computer where it originated. You can't just protect your identity, you to protect the whole process of getting the evidence into the right hands. And one thing that's worked for us is either make a copy or it's the original document and stash it in some place that's out of the way, that it won't be noticed. You basically hidden the evidence within the corporation. You're not taking it out of company property. You're misfiling it. You're putting it in the archives. You're putting it under a tab that is misleading in terms of the substance of that document. And then letting the government know, or the law enforcement investigators know, what documents to demand and ask for. And when the company says that the smoking gun evidence doesn't exist, you can be the navigator and tell the government investigators where to find it. In the calibration fraud case, one of the whistleblowers made maps for 40 FBI agents who went to every file cabinet immediately and got all the documents that made it clear that they were going to be able to prove the fraud. And so there are ways to challenge abuses of power and corruption and minimize the risk to yourselves. 3, whistleblower NGOs, GAP, Government Accountability Project on Government Oversight, and Public Employees for Environmental Responsibility, put out a survival guide about not getting exposed and detected. It's called Choosing Between Conscience and Career, Exposing Abuses Without Exposing Your Identity. And you can get that for free on any of our websites. At GAP, it's on the resources page. All you got to do is click, you can get those educational materials.
Could you tell us where again?
So it's on the GAP website, the POGO website, and the PEER website.
I don't know what, can somebody give me those actual websites? I don't, oh, okay.
Yeah.
I don't know.
The GAP website, I forgot to get the address.
Yeah, that I could.
Whistleblower.
www.whistleblower.org. If you put an S on the end of it, you get over to Gina's office.
And
Very
right out
true.
Whistleblowers of America, you come to our website, and I think we have a resource page that links to some of these other things as well. I want to make sure we have time before we get to lunch, but I also wanted to ask or direct your attention to the fact that we have some foreign nationals from Canada, wave your hands, Ukraine, and Chile. He's in the back right now. So what do these attorneys or whistleblowers from these countries, other countries, we're gonna have a global panel tomorrow morning, but can they bring their cases to the US?
I know you would like that
Yes.
question.
Absolutely. These laws, the whistleblower program laws, they are absolutely international in effect. Some of the best cases have been brought from international whistleblowers. These US corporations are everywhere in the world, or there's enough US connections to be able to bring it back and utilize these laws. Banks are international, finance is international. Everything, not everything, most things that you can find, most fraud and corruption, you can find a link to the international system, which means you can find a link to US jurisdiction. And so you can utilize these laws, be fully protected and fully anonymous, and you don't have to rely on your own government. If you don't trust the government in your own country, you can utilize US authorities, which will do the investigating and protect your identity in the entire process.
I want to make a PS to that. Gina's point is well taken for blowing the whistle and seeking a reward. You can't defend yourself against retaliation under the U.S. laws if you're an international whistleblower. So you're dependent on the existence of protections in your own country if you're retaliated against for going to the U.S. And I would check the fine print to make sure that's protected activity to go to the United States and not to operate within the systems of your own nation.
Yeah, picking up on what Tom said, I think in the EU especially, there is more of a focus on whistleblower protection, but defining whether reporting to a US regulator is protected activity, I think would be key. In Canada, though, they have embraced more the whistleblower rewards concept, at least with respect to their securities commission. I know Toronto Exchange rewards whistleblowers for information similar to the way the SEC does. I'm not as well versed in South America, but please, if you know more about this.
Yeah, I think Oksana wants to make a comment, and then I'll come back to Pamela.
Thank you so much. My name is Oksana Vlovitska, and I'm a lawyer from Ukraine. First of all, I want to thank you for your presentation as lawyers, because it resonates to me as a lawyer, because we also have whistleblowers that call us, and they always want a piece of advice, and sometimes you need to think twice or even 3 times before giving that piece of advice, because it can influence the future of every person. And I've never been a whistleblower. Maybe I will someday. And I've never been in those shoes. And when you give this advice, I'm looking from the perspective as a lawyer, from the perspective of the legislation, and from the perspective of this case, for example, in case of like a trial. But we also have to look at this situation of every whistleblower from the perspective of really mental health and sometimes physical health. And I'm very grateful for Brian for the speech and the feelings of a counselor who was trying to help those whistleblowers that unfortunately passed away. And me and my colleague, we conducted a lot of trainings for the prosecutors, for free legal aid lawyers, and for the c- counselors about the whistleblowers protection, and all our trainings, we started with those two pieces of news about the death of those point whistleblowers. So thank you for sharing this information from your point of view and from your perspective. And that's also the thing that we are pushing in Ukraine, and we're trying to make amendments to the legislation, because in Ukraine, whistleblowers can only seek for counseling and advice when they blew the whistle already. But unfortunately, a person who has some information but hesitates to reveal this information or not has not the right to counsel, and we want to change this. And because sometimes a person needs to know what consequences of his or her actions can be, and how it can influence on his or her life. And what you are talking about, like the international spread of American legislation, United States legislation. So since the full-scale invasion in February 2022 started in Ukraine, we are very grateful because we have a lot of equipment and money coming from the United States and other countries to Ukraine to help us. So, and there are publications, even on the, they are translated into Ukrainian, and they are on the website of our General Prosecutor's Office, that if you have witnessed or if you have any information that, for example, the fraud was committed, or the money that are coming from the United States that are stolen, so you can directly contact the agencies in the United States, and there are the phone numbers and the email through which you can communicate directly with the US government. So thank you.
Thank you.
So I'll just add to that, the Department of Defense Inspector General takes those kind of complaints really seriously. And in Iraq, there's been a lot of litigation over that. But in any war zone where American funds are being spent, it's worth it to encourage clients to contact those Department of Defense investigators.
Yeah, I think some of our veterans actually are some of our best whistleblowers, because they see what's going on the front lines, and they become very proactive in reporting fraud, waste, and abuse, unfortunately, through UCMJ and the Department of Defense. And that doesn't always get anywhere. So we've got to also think about maybe starting a Veterans Against Corruption.
I just quickly, I don't think that we get too excited about Canada doing too much quickly. But I will say that there is one province, that's Ontario, which is leading the way. It's the Ontario Securities Commission. Canada doesn't have a national security commission. And the other province that is just coming online is British Columbia, but they have very limited reward amount. I think it's $500,000. And I believe Quebec is soon going to establish one, if they haven't already done so. But the other thing I wanted to mention, a few years ago, in terms of tips to the SEC, apparently the greatest number of tips came from Canada. Yeah. The SEC. Oh. So we're good on that one. And the other thing I wanted to mention was in terms of lawyers. So I just moved from BC to Ontario. And our organization, Whistleblowing Canada, receives calls from across the country. We're the only organization that is looking at whistleblowing in a comprehensive way, and the only one really, that is receiving calls right now in a country of 40 million people. what I wanted to say was that, you know, living in the largest province, I noticed that, and this is general, and people were calling saying they couldn't find lawyers that would take their cases, that would take whistleblowing cases. So we managed to get funding to do a survey of lawyers, just finished it this year. So we went from 0 to 40 lawyers now who have said, and we just published the directory on our website, who said they will take whistleblower cases. And we've got, you know, we did a comprehensive survey trying to find out what they knew about the law and what they knew about organizational cultures and so on. And we realized a lot of education has to be done, just the kind of things you were talking about today will be. And we got the grant from the Law Foundation of Ontario, which was interesting. We've been trying to get grants ever since we started, which is 5 years ago. And they were the ones that have kind of opened the floodgates. Anyway, of those 40 lawyers, 17 have said they're willing to do initial free consultations and to consider doing pro bono cases. So this is huge, groundbreaking stuff going on in Canada. I am so happy to report because everything else is a total disaster. And we have no effective laws whatsoever. And the other thing that we're doing is we have a lawyer who's now working with us to do educational videos on what rights do exist under other laws. You've mentioned Occupational Health and Safety Act, employment laws, and so on. So we're going to be getting that out into the public as well. And hopefully, I want to engage lawyers, you know, as a small caucus that wants to engage closely with us. And I'm hoping, my vision is that they'll form a Canadian gap. Thank you.
John, that sounds like an assignment for you, a Canadian gap, CGAP.
Something like Canada.
You're everywhere.
So I want to respond to a couple things. So Oksana, right? One opportunity for Ukraine is utilizing the False Claims Act. There's a lot of money flowing into Ukraine with weapons for your defense. And if there's fraud in that, if those weapons are being misappropriated, you should be able to utilize the False Claims Act in order to help prevent that fraud. We can talk about that more if you see any opportunities for that. Another thing is, it really struck me when you said that whistleblowers don't have the right to talk to counsel before they blow the whistle. That is a huge problem. So one thing that I've seen, going back to the mental health focus of this conference, one thing I've seen is whistleblowers come to us and they're engulfed in this community in their workplace that says, no, this is normal. This is normal. This fraud is completely normal. I don't know what you're talking about. You're going insane. You are a problem. You're just a problem employee. And having someone that they can talk to confidentially and safely, like a lawyer, is so important. Someone on the outside who can say, no, 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 no. You're right here. This is very wrong. Everyone, all your superiors telling you that nothing is a problem, they're the ones who are wrong. They're trying to gaslight you. This is a problem. You're in the right place. And telling you where to go from there. Because having someone with you, having someone by your side through this process from the start can be really very, very helpful for whistleblowers. Making sure that you know you're not alone. You're not awash. You have some kind of a North Star of what to do. And, last thing, yes, Canada, so much from all the countries, I think it is, yeah, you're right, the most whistleblower tips to the SEC. I think a close second is the UK, because there's also a huge amount of financial ties between the US and the UK, the US and Canada. And
We get a lot of them back and forth.
exactly. And the UK does not have effective laws. They're working on it. But part of why they're working on it is because the prosecutors in the UK, they're embarrassed because all the whistleblowers there come to the US. They don't use the UK laws because why would they? Because they're not good. they go to the US laws that are more effective and that work and that will listen to them instead of going to the UK. And then the US government will go back to the UK with these UK whistleblowers. So it's a big U shape to utilize the US laws with UK whistleblowers. That's a big emphasis for implementing better laws in these countries.
This is a quick PS to Gina's point. There is hope for Ukraine in terms of communications with lawyers. The EU whistleblower directive does shield those communications, and the lawyer is bound by the attorney-client privilege for it. Ukraine's current whistleblower law doesn't include that protection, but I know that you're working on upgrading it to be compliant with the EU whistleblower directive, because we're working with you guys on it. And I think that's an issue that should be a high priority.
All right, thank you guys. Don't move. So